This week, 4 separate hip-hop trials are opening in American courtrooms, which has never happened before in a single month. One of them starts Wednesday, and it centers on a man who spent the last 22 months in federal custody fighting piece by piece to control exactly what a jury will and won't be allowed to hear about him. That's not a theory. That's not a rumor from a comment section. That's the actual documented substance of the last 6 weeks of hearings in the Lil Durk case, where a federal judge has already thrown out entire categories of evidence, scolded prosecutors from the bench, and left at least 2 more fights unresolved with the clock running out. So before jury selection even begins, here's what's already been kept away from that jury, what's still being argued over in the final days, and why a case that looked settled a year ago just got thrown wide open again. Let's ground this first, because the headlines move fast and the underlying allegation is easy to lose. Durk Banks, known to the world as Lil Durk, was arrested in Florida in October of 2024 and charged in federal court in Los Angeles with murder for hire, conspiracy, and a firearms count tied to a violent crime. Prosecutors allege he financed a plot to kill Georgia rapper Tyquan Bowman, known as Quando Rondo, in retaliation for the November 2020 killing of Durk's close friend and collaborator, King Von, who was shot and killed outside an Atlanta nightclub amid a long-running conflict between Durk's Chicago-based label and collective Only the Family and artists connected to Bowman's own camp. According to the government, the retaliatory plan was carried out in August of 2022 when gunmen tracked Bowman to a gas station near the Beverly Center in Los Angeles. Prosecutors say at least 18 rounds were fired from multiple weapons, including a machine gun, in a matter of seconds. Bowman survived. His cousin, Xavier Robinson, who prosecutors say was standing outside a vehicle linked to Bowman at the time, did not. Durk has pleaded not guilty. He's maintained his innocence throughout, and he's been held without bail since his arrest, denied release multiple times as the case dragged on. He isn't standing trial alone either. Before going any further, it's worth understanding what these specific charges actually require the government to prove, because it's more demanding than the headline version of murder for hire suggests. Prosecutors don't have to show that Durk personally pulled a trigger, and they don't even have to prove he was anywhere near Los Angeles when the shooting happened. What they have to establish to the satisfaction of every single juror beyond a reasonable doubt is that he knowingly agreed to and financially supported a plan for someone else to commit murder, and that the plan used interstate resources or cross-state lines in a way that gives federal courts jurisdiction over it in the first place. That's a real evidentiary hurdle. It usually rests heavily on communications, financial records, and testimony from people who claim direct knowledge of an agreement, exactly the kind of evidence categories that have been the subject of nearly every major fight in this case so far. It also means the defense doesn't need to prove Durk is a good person, or even that he wasn't involved in the broader feud at all. They only need to create genuine, reasonable doubt about that one specific provable agreement. 3 co-defendants, men prosecutors allege were part of the same conspiracy, are set to be tried alongside him, and at least one of their attorneys has already previewed a defense strategy worth knowing about before trial even starts, arguing in an earlier hearing that the government's entire theory rests on what he called a multi-year narrative of violence that has, in his words, zero connection to a specific client, a preview of the kind of individual versus collective argument that 4 defendants sharing one courtroom often produces. That's the core of it. Everything else, the years of hearings, the shifting charges, the fights over what evidence makes it in front of a jury, has been building on top of that same foundation ever since. And building is the right word, because this case has barely resembled a straight line from arrest to trial. The original trial date was set for January of 2025. it didn't happen. It got pushed to October of 2025, citing the sheer scale of what prosecutors were working through, at the time described as roughly 20,000 pages of reports and witness statements, plus more than 200 gigabytes of digital evidence, including surveillance footage and audio recordings. That October date didn't hold either. It moved to January of 2026, then to a spring date, then finally landed on August 20th of this year, the date it's actually held since. Some of those delays came with Durk's agreement, most of them didn't. His attorneys have objected on the record more than once, arguing that every additional month spent behind bars without a trial cuts against his right to a speedy proceeding. A constitutional protection that exists specifically so the government can't simply keep a defendant in limbo indefinitely while it builds its case at its own pace. By the time this week actually arrives, Durk will have waited nearly 2 full years in custody for a jury to hear anything at all. Then, in June of this year, with the trial already delayed multiple times and barely 2 months out, prosecutors did something that genuinely reshaped the entire case. They filed a third superseding indictment, and this one didn't just adjust the existing charges. It added federal racketeering counts under a statute known as RICO, Violent Crimes in Aid of Racketeering, a law originally built to prosecute organized crime and gang enterprises. Here's what that actually means in plain terms. The original case was about one specific alleged plot, one shooting, one intended target. A racketeering charge is different, and it's worth slowing down on because it changes the entire shape of a trial. It doesn't require prosecutors to prove a single isolated crime beyond a reasonable doubt and stop there. It lets them argue that an entire ongoing organization, in this case Durk's own label and collective, Only the Family, functioned as a criminal enterprise, similar in legal structure to how prosecutors have gone after organized crime families for decades, and that a whole pattern of separate violent acts, potentially spanning years and states, were all part of the same alleged scheme rather than isolated, unrelated events. Practically, that means a jury doesn't just hear about the one incident they're there to decide. They can potentially hear about years of alleged conduct that never resulted in charges against the person on trial, used instead to paint a broader picture of the organization around him. That's exactly why defense attorneys tend to fight racketeering editions as hard as they do. It doesn't just add charges, it can fundamentally change what a jury is allowed to consider when they're deciding guilt on the original ones. To support that new theory here, the government tried to bring in 2 incidents that had nothing to do with the Los Angeles shooting at all, a 2019 shooting in Atlanta and the January 2022 killing of a rival Chicago gang member, a case in which Durk himself was never separately charged, but which prosecutors argued was connected through an alleged cash reward tied to Durk's studio. That expansion is the single biggest reason this case looked completely different in July than it did in May, and it set up the most consequential hearing of the entire prosecution so far. On July 14th, both sides appeared in front of U.S. District Judge Michael Fitzgerald, and by every account from reporters who were actually in that courtroom, it did not go the way prosecutors were hoping. The government's argument was that the Los Angeles shooting and the newly added Chicago and Atlanta allegations were fundamentally the same story, different chapters of one alleged criminal enterprise that couldn't fairly be separated for a jury. Durk's defense team pushed back hard, calling the new charges, in their own words, lipstick on a pig, and arguing the 11th hour timing amounted to an acknowledgement that the government's original case wasn't strong enough to stand on its own. Judge Fitzgerald spent much of the hearing pressing prosecutors on one specific question: if this material was so central to their theory, why had they waited until 11 weeks before trial, after 22 months of preparation, to bring it forward at all? He wasn't satisfied with the answer. In his ruling issued that same day, he severed the new racketeering charges entirely, ordering that they be tried separately on a date not yet set, while the original Los Angeles case proceeds exactly as scheduled. Reporters in the room described him as openly skeptical of the government's motives, at one point characterizing the timing as a calculated move rather than a genuine investigative development. Durk's lead attorney, Drew Findling, called it one of the more rewarding days of his career as a trial lawyer. So walk through what that actually accomplished, because it's easy to undersell. The jury being seated this week will not hear about the 2019 Atlanta incident. They will not hear the government's theory connecting Durk to the 2022 Chicago killing, or the allegation that he brought cash to a studio afterward as a reward. None of that gets argued in front of them, at least not in this trial. That's a real, significant, legally consequential thing the defense fought for and won. Weeks before opening statements, and it happened in open court, on the record. Which is exactly why it's strange that so much online conversation about this case still treats the racketeering allegations as though they're part of what jurors will be weighing this month. They aren't. Not yet. And maybe not ever. Here's why that maybe not ever matters. And it's a genuinely interesting legal wrinkle most coverage of this case has skipped past. If Durk is acquitted on the original Los Angeles charges this month, his attorneys could potentially argue that pursuing him again on the severed racketeering counts raises double jeopardy concerns. The constitutional protection against being tried twice for the same underlying conduct. Prosecutors would likely counter that the racketeering charges involve legally distinct conduct, different incidents, different alleged victims, which is exactly why the government fought so hard against severance in the first place, rather than simply agreeing to it. Judge Fitzgerald didn't resolve that future fight in July. He didn't need to, but it means the government's decision to add those charges when it did and lose the fight to keep them attached to this trial could end up mattering just as much for what happens after an August verdict as for what happens during it. That's the biggest fight the defense has already won. It is not the only one still being argued in these final days, and one of the ones still unresolved involves something that's been sitting in a police evidence room for years. Durk's legal team is asking Judge Fitzgerald to block prosecutors from using a specific text message at trial, and the argument isn't about what the message says, it's about where it's been. According to the defense filing, the phone that message came from has been in government custody since a 2021 investigation, but federal investigators didn't actually seek a warrant to search its contents until this past month, nearly 2 years into an active prosecution that's already relied heavily on digital evidence. That gap matters more than it might sound like it should. When evidence sits untouched for years before investigators formally examine it, defense attorneys can reasonably ask what changed, why now, and whether the delay itself raises questions about how reliable or how central that evidence actually is to the government's case. A hearing on that specific motion was scheduled for August 13th, 1 week before jury selection. As of the most recent reporting available, no ruling has been made public. Whatever the judge decides, it's a clean example of exactly the kind of fight this entire case has been built on, not whether something happened, but what a jury is legally permitted to be told about it. Digital evidence hasn't been the only recurring flashpoint. Since well before this year's hearings, prosecutors have also pushed to use Durk's own music as evidence, specifically lyrics from a 2021 remix that the government contends directly referenced tensions with Bowman. A judge ruled earlier in the case that at least some of that material could be introduced at trial. Cases like this one increasingly hinge on exactly this kind of dispute. Less about whether a fact exists and more about how it was collected, when it was collected, and whether the process itself was fair. Digital evidence in particular has become one of the most litigated categories in modern federal prosecutions, precisely because it's so easy to gather in bulk and so hard for a jury to properly weigh without expert context. A phone doesn't come with a plain language explanation attached to it. Location data, message metadata, and deleted file recovery all require someone, usually a paid expert witness for each side, to translate raw technical output into a story a jury can actually follow, and those two experts frequently disagree with each other in ways that leave jurors choosing which narrative to trust rather than which fact is simply true. That's exactly the terrain the text message fight sits on. It's not really a dispute about a single sentence and a single message. It's a dispute about whether the process that produced that message in a courtroom years after it was first seized can be trusted enough to put in front of 12 people deciding a man's freedom. This sits inside a much bigger, genuinely unsettled debate across the entire American legal system right now, whether an artist's lyrics written in character, in a genre built almost entirely around portraying violence in street life as a narrative device, should be treated by a jury the same way as a private confession. It remains legal in federal court, where Durk is being tried, and prosecutors clearly believe it strengthens their case. His defense has fought its inclusion at multiple points, arguing lyrics are performance, not testimony. The pushback against this practice hasn't stayed confined to individual courtrooms. California passed a law in 2022 specifically restricting how prosecutors can use an artist's creative work against them at trial, requiring judges to weigh whether the material's value as evidence actually outweighs the risk that a jury will simply assume the lyrics are a confession because of the genre they belong to, rather than evaluating them like any other piece of evidence. Lawmakers in several other states have proposed similar restrictions, largely in response to years of cases, including the Weissel prosecution Brian Steele just came out of, where prosecutors leaned heavily on rap lyrics to help paint defendants as members of a violent enterprise. None of those state-level protections apply here. Since this is a federal case in California, but governed by federal rules of evidence, not the state statute, that gap, a legal protection that exists in the state where the trial is physically happening but doesn't apply to the federal charges being tried there, is itself become part of the broader argument critics of the practice keep raising, that whether an artist's own words can be used against them currently depends less on fairness and more on which courthouse happens to be hearing the case. Then there's a fight that isn't about evidence at all, but about who gets to talk while all of this plays out. In the final weeks before trial, federal prosecutors asked the court to impose a limited gag order, seeking to bar attorneys and others closely tied to the case from making public statements that could reach and potentially influence the jury pool before a single juror is ever seated. The government pointed specifically to social media activity from Durk's own account and to defense attorney Drew Findling's media appearances as examples of exactly the kind of public commentary they wanted restricted. It's a genuinely telling request because it's essentially the government arguing days before trial. That public conversation about this case has become loud enough to be a real risk to a fair proceeding, which tells you something about how much attention this case has already generated before a single witness has been sworn in. That motion, like the phone dispute, was set for a hearing on August 13th, and as of the most recent available reporting, Judge Fitzgerald hadn't yet ruled on it either. One more piece is still being worked out, and it involves the 16 people who will actually decide this case. Prosecutors have asked the court to keep the identities of the seated jurors anonymous throughout the trial, citing security concerns given the nature of the allegations. Judge Fitzgerald hasn't rejected that request outright, but he's also indicated the court still needs to work out the precise procedure for how it would function. Meaning even something as basic as whether jurors' names will ever become public wasn't fully settled as this went to trial. Anonymous juries aren't unheard of in cases involving allegations of serious organized violence, but they're also not standard practice, and defense teams generally resist them, partly because there's a reasonable argument that asking jurors to stay anonymous can itself subtly suggest to them that the defendant is dangerous before they've heard a single piece of testimony. Behind all of these individual fights sits a legal team that's become its own storyline. Durk brought on attorney Brian Steele earlier this year, a lawyer with a specific kind of credibility in exactly this world. Steele represented Young Thug through the sprawling Wessel racketeering trial in Fulton County, Georgia. One of the most closely watched gang conspiracy prosecutions in recent hip-hop history, and his addition to Durk's team reads, "To anyone following these cases closely," as a direct signal of how seriously the defense is treating the racketeering threat even after winning the severance fight. That comparison is worth sitting with for a moment because it cuts both ways, and it's probably the clearest illustration available of exactly what's at stake in a racketeering prosecution. Young Thug spent more than 2 years in custody before that case ever reached a verdict through what became the longest criminal trial in Georgia state history, nearly a year of jury selection alone before testimony even began. It's a state-level racketeering case rather than the federal version Durk is now facing separately. But the underlying legal machinery works the same way. Prosecutors used Georgia's RICO statute to argue that an entire record label and its associates functioned as a criminal street gang, weaving years of alleged, mostly uncharged conduct into one sprawling narrative. That's exactly the model federal prosecutors tried to import into Durk's Los Angeles case in June, before Judge Fitzgerald cut it loose. And here's the part that makes the comparison genuinely double-edged rather than simply alarming. Young Thug's case didn't end in the outcome the racketeering framing seemed to promise. After 2 years in jail and facing a potential sentence measured in decades, he ultimately entered a plea no contest to the top racketeering count. Guilty to a handful of lesser drug and weapons charges, and walked out of the courtroom that same day on time served, with a lengthy probation term hanging over him rather than additional prison time. Steele was in the room for all of it. Whatever the outcome ends up being in Durk's own eventual racketeering trial, once it's scheduled, the Young Thug case stands as recent. Direct proof that these prosecutions are neither a guaranteed conviction nor a quick process, and that the stakes of simply sitting inside one, regardless of the eventual result, are measured in years of a person's life before a jury ever reaches a verdict. Durk's wife, India Royale, has shown up to hearings throughout, including the pivotal one in July. And Durk himself, in the months leading up to trial, has occasionally broken his public silence in smaller, quieter ways, posting at one point online about how isolation reveals who actually stays close to you, a brief, unguarded moment from a man who spent nearly 2 years watching his case get rebuilt around him from inside a federal detention facility. Zoom out for a second, because the scale of what's happening this month is its own kind of story. Durk's trial isn't happening in isolation. It's one of 4 major hip-hop adjacent criminal trials opening within roughly the same few weeks. 10 days before jury selection begins in Los Angeles, a Las Vegas courtroom opened proceedings in the case tied to Tupac Shakur's 1996 killing. Nearly 3 decades after the fact, with prosecutors arguing that a defendant's own public statements about that night, made in interviews and in his own memoir years before any arrest, help establish his role in setting the murder in motion. Later the same month, separate cases involving artists Yella Beezy and All-Star Jr. are set to open in their own jurisdictions. One centered on another alleged murder-for-hire plot, the other on a federal gun charge stemming from a shooting at a Houston restaurant. Legal analysts covering the industry have called it an unprecedented stretch for the genre. 4 different courtrooms, 4 different juries, all wrestling in the same narrow window with the same underlying question the culture has been arguing about for years, where the line actually sits between an artist's persona, their art, and their exposure to the actual justice system. So here's where that leaves the case as it actually walks into a courtroom this week. Stripped of everything that's been added and then quietly taken back away. The jury will not hear about Atlanta. They will not hear the government's Chicago theory. Whether they hear a specific text message from a years-old phone, whether the defense and prosecution's public statements get restricted going forward, and whether the 16 people deciding this case will ever be publicly identified. All of that was still genuinely unresolved as of the most recent filings available. What remains at the center of everything is the original allegation that Durk financed a plan to kill a rival artist, and that a plan like that ended a different young man's life instead. Prosecutors believe they can prove that beyond a reasonable doubt. Durk's defense has spent nearly 2 years and an unusually aggressive final 6 weeks, arguing that large parts of what the government tried to build around that core allegation don't belong in front of a jury at all, and on more than one occasion a federal judge has actually agreed with them. None of that tells you how this ends. It tells you that the version of this case a jury actually sees this month is already meaningfully smaller and more contested than the version that's been circulating online for the better part of 2 years. What happens once testimony actually starts is still completely unwritten. What do you think happens once the racketeering case comes back around, win or lose here?